Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This is our second part of a three-part series dealing with major municipal court and criminal cases, and it's part of the New Jersey State Bar Association and Institute for Continuing Legal Education annual seminar dealing with recent criminal court cases. And we're next looking at the post-conviction relief cases. Court Rule 7:10-2 was amended to require post-conviction motions to be heard within 5 years. Can the 5-year period be waived? And the answer is yes. The 5-year post-conviction limit can be relaxed in a DWI State versus Bringhurst. In this case, they said the time limits may be relaxed to prevent injustice because a post-conviction relief case cannot be brought until there usually is a second or subsequent DWI conviction. The time bar should not mechanically be applied to deny the petition. However, to obtain the benefit of relaxation of the time limit, the defendant must put forth a prima facie case for relief in his petition. And unfortunately for this Bringhurst fellow, although they relaxed the period, they denied his petition. Let's see. What if there's no transcript? Let's say, can a judge hear a PCR motion if it's not in the original court? And the answer is yes. In an unpublished case, State versus Binklewitz, the Appellate Division held a 30-year-old uncounseled DWI conviction could not be used to enhance jail. And they looked at the fact that said that they relied upon what the defendant does, their testimony and certification, that he did not know he was entitled to counsel. He was not asked if he wanted an adjournment to obtain counsel. That was sufficient to establish the conviction was uncounseled. Let's say, and since the conviction was uncounseled, and since the subsequent convictions exceeded the 10-year time span, the judge correctly applied the step down and sentenced him as a second offender with respect to incarceration. Therefore, he did not have to do the 180 days in jail. And that was the unpublished case of State versus Binklewitz. Let's see. Moving on to other criminal type matters. Can police access a defendant's internet records? Answer is no. State versus Reid. Under the New Jersey Constitution, the Supreme Court of New Jersey held that citizens have a reasonable expectation of privacy in the subscriber information they provide to internet service providers. They said the motion to suppress by the defendant was properly granted because the police used the deficient municipal court subpoena. Law enforcement go through the county prosecutor's office with a grand jury subpoena. However, in this case, they said they can reacquire the information with a proper grand jury subpoena, in that it was not barred by double jeopardy. Let's see. The police departments and law enforcement have a criminal database. Let's say, let's say the police are on a car stop and get a passenger's name. Can they look up for past arrests or warrants on the NCIC? Doesn't that violate someone's rights, especially if they're just a passenger? And the Supreme Court of New Jersey in State versus Sloane said no. The police do not need reasonable suspicion before they access the NCIC database. During the motor vehicle stop, the passenger, like the driver, is seized, but the police do not need reasonable suspicion before they access the database because it was in the scope of the simple traffic stop. Ordinances. Many municipalities have different ordinances. Let's see. Is a municipal noise ordinance preempted by state law? And the Appellate Division, State versus Krause, said no. It's not preempted by state law, and that's a good decision because it gives municipal prosecutors the opportunity to amend criminal charges to ordinances so the towns can make more money. Searches of commercial vehicles. Can a commercial vehicle be searched for contraband during a safety inspection. Yes, State versus Hewitt, a commercial vehicle could be searched during a routine inspection. In this particular case, let's say a police officer makes observations during a routine safety inspection of a commercial truck that reasonably believes him to believe it contains a hidden compartment containing contraband. Is not required to obtain a search warrant before undertaking to confirm the existence of the hidden compartment and determine its contents. And that was State versus Hewitt. Next is DWI refusal cases. In a DWI arrest, the police read the first sections of paragraph 36 warning. You must take the test. You have no right to an attorney. Let's say the person first says they'll take it, then they change their mind. Well, there is a section that says that unless the defendant says yes, police officer is supposed to read the second portion. What if they don't? If the police officer does not read the second portion of the warning, should a refusal be tossed? It's unclear. Now, the Appellate Division previously the lower court ruling in State versus South ordered the police to always read the second paragraph unless the defendant takes a test. In State versus Spell Supreme Court reversed and said the Appellate Division does not have this mighty power to compel the police to do anything. They said the legislature has vested in the Motor Vehicle Commission the authority to determine a standard refusal statement, and it shouldn't be up to a municipal court. No point tickets. The statute 97.2 says that if it's a first or second offense, that there's no points. If on a third offense, there's 4 points, but if 5 years go by, there's supposed to be no points, essentially a step down. Let's say, so that's what the statute says. What does the Appellate Division say? Well, in Patel versus NBC, let's say the Appellate Division said the unsafe driving provides the Motor Vehicle Commission shall assess motor vehicle points for a third or subsequent offense. Let's say, and that's, I don't think that the Appellate Division is right, and neither does Senator Kip Bateman, because fortunately he has introduced legislation to correct this, to make it specifically clear that if it's your third offense, but 4 years went by, there should be no points, period. And hopefully that legislation will pass. Let's say someone has a DWI trial, or they take an additional guilty plea after losing a suppression motion. Can they then try to appeal up and work at a better deal with the county prosecutor? Well, not in Mercer. No plea bargain of a DWI appeal. State versus Rastogi. The Law Division held the Law Division may not accept a plea bargain to resolve a de novo appeal of a DWI. I disagree with that, but that's the decision by at least one lower court law division. For additional information and representation on criminal and traffic tickets, call the law office of Kenneth Vercammen, 732-572-0500, 205 through Woodbridge Avenue, Edison, New Jersey, on the web at www.njlaws.com, that's njlaws.com, or benotguilty.com, that's benotguilty.com. And we'll be posting on our website and YouTube the next portion of the annual seminar, Major Municipal Court and Criminal Cases in the Past Year. Thank you.